Good day. I am Mary Grace Galanida from BSHM3A, and I am going to tackle today the Chapter 1 of the Legal Aspects in Tourism and Hospitality, the Introduction. Ignorantia juris non excusat, or ignorance of the law excuses no one. It means not knowing about the law is not a valid excuse for breaking it. In other words, everyone is expected to know and understand the law, and saying, I didn't know it was illegal, will not spare you from the punishment if you break the law. So it simply means that laws are necessary for maintaining orders and peace in society. So without laws, there would be a chaos and disorder, making it hard to achieve peace. So here are our learning objectives. First, identify the different kinds of laws relevant to tourism, travel, and hospitality industry. Explain the concept of tourism law. Enumerate important sources of tourism law. And lastly, give examples of applications of tourism law. Definition of law. In its general and abstract sense, it is the science of moral laws founded on the rational nature of man that governs his free activity for the realization of the individual and social ends of life under the aspect of mutual conditional dependence. So the phrase essentially means that law in its broad and abstract sense is the study of ethical rules based on a human rationality. So kaning mga rules will guide our free actions towards achieving personal and societal goals, while also considering the interdependence among the individuals in a society. So for example, the laws acknowledge our interdependence. So if one company pollutes a river, it affects all the people who rely on that river for water. So the law is there to ensure that in pursuing our individual goals, like running a business, we don't harm others in our society. Furthermore, in its specific and concrete sense, it is defined as a rule of conduct, just and obligatory, promulgated by legitimate authority, and of common observance and benefit. So, in this context, a law is a fair rule that everyone is required to follow. It's set by the trusted authorities, such as the government, and is intended to benefit everyone in the community. So, a good example would be the speed limit law. The government, a legitimate authority, sets a maximum speed limit that all drivers must observe on specific roads. So these rules is just an obligatory, meaning it's fair and everyone must follow it. So the speed limit law is a common observance because all drivers, regardless of who they are must observe it. So it's of common benefit because it helps prevent accidents, ensuring the safety of all roads users. So by following these laws, we contribute to a safer community for everyone. Next is the kinds of law, its purpose. Substantive law, a law which creates, defines, and regulates rights, or which regulates the rights and duties which give rise to the cause of action. So it means that substantive law is the part of law that tells us what our rights are and what we can or cannot do. For example, criminal law is an example of substantive law. So it defines what constitutes a crime such as theft or murder and sets out the rights of an accused person and the obligations of the prosecution. So second is the adjunctive law, a law which provides the methods of aiding and protecting certain rights. So it means that adjunctive law is a part of law that tells us how to enforce our rights and how illegal proceedings should be conducted. For examples, the rules of court that governs how a criminal trial should be conducted are an example of adjunctive law. So they set out the procedures for things like filing charges, presenting evidence, and appealing a verdict. So these rules ensures that the rights and obligations defined by the substantive law are upheld. Kinds of law, the scope. So the first one is the general or public law, a law which applies to all of the people of the states or to all the particular class of persons in the states with equal force and obligations. So it means that general or public law is a law that applies to everyone in the states or a specific group, and it has the same level of importance and obligation for all. For example, the constitution of a country is an example of general or public law. It applies to all citizens within that country, so regardless of their social status, occupation, or any other factors, the rights and responsibilities outlined in the constitutions are equal applicable to all individuals. So second is the special or private law, a law which relates to particular persons or things of a class. So meaning, special or private law is a law that is specific to a certain individuals or things within a particular group. For example, family law is an example of a special and private law. It deals with the matters such as marriage, divorce, child custody, and adoption. So these laws apply to individuals or families who are directly involved in these specific situations, rather being applicable to the entire population. So let's jump in the concept of tourism law. Tourism law may be defined as a body of rules or principles of actions which deals with the regulation, authority, relations, and obedience among members of the society involved in the tourist travel and accommodation. So in other words, tourism law consists of rules and principles that guide and regulate the behavior, interactions, and compliance of individuals involved in the tourist travels and accommodation within the society. So one of the example of tourism law is the requirement for hotels to maintain certain safety standards for the well-being of their guests. So these standards may include fire safety measures, building codes, hygiene regulations, and accessibility provisions. So these rules ensures that tourists are provided with a safe and comfortable environment during their stay. So compliance with these regulations is necessary to protect the rights and interests of both tourists and the tourism industry. Now let's proceed to the importance and application of tourism law. So the importance and application of tourism law lie in understanding and complying with the principles and regulations that governs the diverse sectors of the tourism industry. So it is crucial for businesses to operate legally and for the government to regulate and support the sustainable development of tourism. So, an example of the importance and applications of tourism law can be seen in the licensing and regulation of travel agencies. Governments may require travel agencies to obtain specific licenses and meet certain criteria to ensure the safety and protection of tourists. So, these regulations help maintain the quality and reliability of travel services provided by agencies, protecting the interest of both tourists and the tourism industry. So by adhering these laws, travel agencies can operate legally and gain the trust of their customers, contributing to the overall growth and success of the tourism sector. And now let's proceed to the sources of law relevant to the tourism, travel, and hospitality industry. So the first one is the Philippine Constitution. The Philippine Constitution is the fundamental law of the land, and all other laws must conform to its provisions. Second is the statutes of legislative enactments. So these are written laws created by the legislative department. They prescribe rules and regulations that govern actions and conduct in relation to persons and things. So examples include the Dangerous Drug Act, Public Service Act, Civil Code of the Philippines, Labor Code of the Philippines, Revised Penal Code, Seatbelt Law, and the Local Government Ordinances. The third one is the administrative or executive orders, regulations, and ruling. So these are issued by the administrative officials under legislative authority. Examples include rules and regulations governing the accreditation of accommodation establishments issued by the Secretary of Tourism, circular of the rulings from the Bureau of Internal Revenue, administrative insurances by the Department of the Foreign Affairs, and the omnibus rules of implementing the Labor Code of the Philippines. Fourth is the judicial decisions or jurisprudence. So this refers to the decisions made by the Supreme Court in interpreting laws or the Constitution. Judicial decision serves as precedents and guide the application and interpretation of the law. Fifth is the custom. Custom refers to the rule of conduct that has been followed for a significant period of time among specific groups of people in a particular place. And lastly is the other sources. These include decisions from the foreign tribunals and opinions of textbook writers which may provide additional guide and insight of legal matters. So that ends for my discussion. Thank you and have a good day.